Good evening, everyone. On behalf of Dadari CP Study Circle, I welcome you all to the today's seminar on new code of ethics. We have with us Shreya, who will be guiding us through the new provisions and with practical case studies, which will be helping us in the future. So, without taking much of time, I request Parin to play ICI motto. Parin.
य एष सुप्तेषु जाग्रति य एष सुप्तेषु जाग्रति कामं 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 कामपुरुषो पुरुषो निर्विमाणः निर्विमाणः तदेव शुक्रं तद्ब्रह्मा तद्ब्रह्मा तदेवामृतमुच्यते तस्मिन् लोकः शतः सर्वे तदूनात्यपि कश्चन एतद्द्वैता 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 एतद्द्वैता.
Thank you, Parin. Now I request member Jeel to the speaker. Jeel.
I would like to thank Dadari Studies for giving me this opportunity. Led the discussions on direct tax case study papers in RRC for 2 years and has contributed articles on taxation on various professional forums. She has been co-op as a committee member of editorial board ICAI for the year 1920, strategy perspective planning and monitoring committee ICAI for 2021, and ethical standard board ICAI for the year 21-22. I would now request Parin sir to present certificate of appreciation to her.
Thank you, Jean. Just a second. Hi, Shreya. So, in this online times, please accept a e-certificate on behalf of the Dadari CP Study Circle, and we thank you for accepting our invitation.
Thank you, Parin, for such a kind gesture.
Yes, yeah, you can start talking.
Parin, is my screen visible?
Yes, yes.
Okay. Thank you, Zeel, for such a kind introduction. First of all, I would like to thank Dadari CP Study Circle and Parin Gala for giving me this opportunity to share my views on Code of Ethics. So today's presentation's coverage will be Introduction to the Code of Ethics. We'll discuss about the conceptual framework. We'll see what are the major changes in the Code of Ethics 2019, and we'll discuss some case studies. Our signature is far more important. We are the pillars of the economy. So therefore, many stakeholders, society at large, put faith in our signature. They take decisions on the basis of reports we issue. Therefore, ICI is of the view that each and every member should be aware of the code of ethics, what are our ethics, and should be updated with the revisions and council guidelines. That's why these seminars are conducted. So let us start with it. Ethics means moral principle. Ethics governs person's behavior. Professional ethics consist of personal, organizational, and corporate standards of behavior expected for professionals. How we professionals as a community to behave in a public at large, ethics governs us that. So, lawyer has a duty towards his client, immediate duty towards his client only. So even the client is at fault, lawyer is going to defend him. But we as a chartered accountant, we as a professional accountant, if our duty is towards stakeholders, towards society at large. So if our client is wrong, we are not going to defend him. We are going to bring that wrong in the knowledge of the public. Correct? So ICI says that ethics should be in your blood. So to prevent you from taking any temptation that comes in your mind to work on to prevent you working on a selfish motive. Code of ethics establishes ethical requirements for professional accountant. So one may doubt as why ethics when there is law? To ensure credibility, which is the foundation of our profession. Ethics is required to encourage people to maintain rightful professional conduct, though law is mainly to punish. Okay, so ethics comes first. So for example, we are all aware that while conducting an audit, we are supposed to be independent. We are, if our independence is affected, then we have to apply safeguards. We have to think whether we should accept the assignment, not accept the assignment, etc., etc. So all this is discussed in code of ethics. So code of ethics prevents us from contravening any laws or regulations and prevents us from the punishments. So therefore ethics is the basis of law. Now ethics in accountancy. A distinguishing feature of accountancy profession is its acceptance of the responsibility towards public as a large. Code of ethics seeks to protect the interest of the profession as a whole. I think you all will agree with me when I say if the code of ethics wouldn't have been there, then the respect that we are getting as a professional community wouldn't be there. Respect, it wouldn't be having the same respect that we are getting right now. Therefore, code of ethics acts as a shield that enables us to command respect. So International Federation of Accounts, IFAC, has established International Ethical Standard Boards for Accountants, that is ISBA. Now ISBA develops ethical standards and guidelines for the use of professional accountants. ISBA encourages member bodies to adopt high standards of ethics for their members and promotes good ethical practices globally. The ISBA also fosters international debate on ethical issues faced by accountants. Since we are the member of the ISBA, we have adopted those ethical standards and conversed according to our domestic requirement. We have not adopted as it is, but we have conversed with it. Ethics are there since the human inception. So even ICI is complying the ethics since its inceptions. ICI Chartered Accountant Act 1949 enacted by Parliament for regulation of profession and for the public object of the Act. Chartered Accountant Regulation 1988 enacted. Chartered Accountant Act has two schedules where misconduct is defined. Now, history of code of ethics. So earlier there was a code of conduct for the member. Then code of conduct was called as code of ethics for the first time in its 9th edition in 2001. Then came code of ethics 2009. It was the first edition with the convergence with IFAC. Now there is revised code of ethics 2019, which we are going to see today. Now, broad comparisons between 2009 versus 2019 edition. Code of Ethics 2009 had two parts, A and B. Part A based on ISBA code as suitably incorporated, and Part B based on domestic provision governing members. Now, Code of Ethics 2019 has 3 volumes, which are which are already being effective from 1st July 2020. Volume 1 is revised counterpart of Part A 2009 edition based on ISBA Code of Ethics. Volume 2 is revised counterpart Part B. Volume 3 is updated with relevant disciplinary case laws. Very fun module to read. Now, structure of Code of Ethics 2019. Part 1 is applicable to all the professional accountants. It speaks about complying with the code, fundamental principles, conceptual framework. Part 2 is professional accountants in service, and Part 3 is for professional accountant in public practice. It also speaks about the International Independence Standard, parts 4A and 4B. Part 4A, independence of audit and reviews. Part 4B, independence for other assurance engagements. Now, we are all aware there are 2 schedules of misconduct. First schedule is relevant to internal to the professionals, and second schedule is when outsiders are affected. So, for example, if I am going to accept an audit assignment, I have to communicate with the previous auditor. So that is internal to the profession. But if I saw some fraud in the company and I'm not reporting the fraud, then the outsiders are affected. The society is affected. Therefore, here it will come under second schedule. So these are the there are the 4 parts in the first schedule, and there are number of clauses in each schedule, and there are in second schedule there are 3 parts. So these are the clauses and the names. Now, what is professional or other misconduct? Let us look at the definition. Professional or other misconduct shall be deemed to include any act or omission specified in any of the schedules, but nothing in the section shall be construed to limit or abridge in any way the power conferred or duty cast on the director under such section 1 of section 21 to inquire into the conduct of any member of the institute under any other circumstances. So what professional misconduct has been defined in part 1, part 2, and part 3 of the first schedule, and part 1 and part 2 of the second schedule. A member who is engaged in the profession of accountancy, whether in practice or in service, should conduct or restrict his actions in accordance with the provisions contained in the respective parts of the schedules. Okay, so when you are guilty of any acts or omissions as respect to the respective parts of the schedule, while complying your professional duties, then that will be a professional misconduct. Now, what is other misconduct then? Misconduct under any other circumstance. What is that? So other misconduct has to be determined on case-to-case basis, keeping in view the facts of the circumstances of each case. Fraud, intention to deceive, committing an act which affects the public or society at large could be an ambit of such misconduct. So we as a chartered accountant are supposed to maintain higher standards even where we are not performing professional duty. So for example, if I'm traveling in a local train without a proper ticket, then it can amount to other misconduct. So examples are here: conviction by competent court for offense involving moral turpitude, using article assistance service for purpose other than professional service, material misrepresentation, publishing ad with malafide intention or to malign any person, and using abusive language. So we as a chartered accountant are expected to have a higher morale even when we are not in a professional capacity or performing any professional duty. So while performing our duties as a professional, the knowledge of laws and other regulations affecting a particular assignments is fundamental. So what ICI says is you should constantly bear in mind the provisions of the CA Act, stay updated with the code of ethics, stay updated with the ICI guidelines, council guidelines, notifications by ICI, because violations of these pronouncements doubtless is a professional misconduct. So let us discuss about the conceptual framework, fundamental principles. So Act says that there are 5 fundamental principles: integrity, objectivity, professional competence and due care, confidentiality and professional behavior. Part A now, Volume 1 establishes conceptual framework for all the members to ensure the compliance with these 5 fundamental principles. It is compulsory to you that you have to ensure the compliance with these 5 fundamental principles. First is integrity. You are supposed to be straightforward and honest in all your professional relationships. Bhai kuch wrong hai to wrong hai. You have to communicate that. You have to be honest and straightforward. Objectivity. Do not allow any bias, conflict of interest, or undue influence of others to override your professional judgment. Because of any other decision, others' judgments, your professional judgment should not be affected. Professional competence and due care. Maintain professional knowledge and skill at the level required to ensure that the client or employer receives competent professional service based on current developments in practice, legislation, and technique. So whenever you are accepting an assignment, make sure that you have required expertise, required competence, required knowledge to handle that assignment, and the required confidence to handle that assignment. Confidentiality. The confidentiality of information acquired should not disclose any such information to third parties without proper and specific authorities unless there is a legal or professional right or duty to disclose. Confidential information required as a result of professional and employment relationship should not be used for the personal advantage. Right. So I came across certain case study yesterday that by speaking in the one chartered accountant, by speaking in the public forum on certain topics flow in flow he talked about certain clients information, clients business information. So and the next moment he was liable of professional, he was guilty of professional misconduct. So make sure that we maintain proper confidentiality and integrity. Professional behavior. We should comply with relevant laws and regulations and should avoid any action that discredits the profession. Now, we are supposed to comply with these fundamental principles. While complying with these fundamental principles, we may come across certain threats. For example, first is self-interest. Where if partner or if my partners or any of the relatives of my or my partners has any financial interest or other kind of interest in the client's business, client's entity's business, then there is a self-interest threat. For example, any of my relative has invested in the shares of the company, then I will always wish that his business grows. Or if there is a overdue fees, then in case of overdue fees, we are always we might be scared to speak against the management because our fees is pending. Self-review threat. This may occur when a professional judgment needs to be re-evaluated by the professional accountant responsible for that judgment. So here maker and checker when they are not different. For example, I am only writing the books of accounts and I am only auditing those accounts. So there might occur self-review threat. Advocacy threat, which may occur when professional accountants promotes a position or opinion to the point that subsequent objectivity may be compromised. For example, when I am representing client on advocate level, that I am promoting his business or I am promoting his shares of the company, then there might occur advocacy threat. familiarity threat. This may occur when, because of relationship, professional accountant becomes too sympathetic to the interest of others. So I have a long relationship with my, I have a long association. We are working together since many years with the client. And because of that, there is a personal relation which is built up. And therefore, I will think, I become sympathetic towards him. So I will think thousand times with that entity, with when I want to, come with some bad, some qualification. I will think about that entity first. So that is a familiarity threat. Intimidation threat. When a client business entity is in a influential or powerful position that it affects my decision, okay, that is an intimidation threat. So how do we safeguard for how what safeguards we can apply to mitigate or reduce this threat? So safeguards created by profession, legislation, or regulation include, but are not restricted to, educational training and experience requirement for entry into profession, continuing professional development and requirements. So make sure that while accepting an assignment, you have required competence knowledge to handle that assignment. Corporate governance, regulation, professional standards, professional or regulatory, monetary, and disciplinary procedures. So make sure that you comply with the all the acts and laws governing to the assignment. And we can always get our work reviewed by third professional accountant. Our work, our reports, our communications, our information, our documentation, anything, we can always get it reviewed by professional accountant. Safeguards in the work environment. So we have to comply with the fundamental principles. So whenever we are communicating with our team, give a stress on the point that we are here to act in a public interest, not in a client's interest, but we are here to act as a public interest and we will comply with the fundamental principles. Safeguard documented policies and procedures to implement and monitor quality control of engagements. For assurance engagements, document independent policies requiring document the requirements regarding the compliance with the fundamental principles. And whenever you come across certain threat, document such thing and how did you handle that threat, what safeguards you applied, how did you apply, document that too. And all these documentations of policies and procedures should be shared with your team member. Keep them updating, keep taking seminars with them, and designate a member of senior management to be responsible for overseeing the adequate functioning of the firm's quality control system. Now, sometimes we are relying upon the revenue, upon the single client in terms of revenue. For example, the revenue from the single client is very high. So keep assessing and monitoring the situation, and because of this, and keep assessing that because of that, our independence, our decision making capacity is affected. For using different partners and engagement teams with separate reporting lines. Engagement specific safeguards in work environment may include involving additional professional accountant to review our work, consult and independent third parties such as community of independent directors, professional regulatory body, or any other professional accountant. Discuss the ethical issues with those charged with governance. Discuss with them our nature of services and the extent of fees charged by us, and keep rotating the senior personnel of the team. Now, safeguard within the client system and procedures. When a client appoints a firm in public practice to perform an engagement, persons other than management whether ratify or approve an appointment. Competence, assess the competence of client employees to with regards to experience and seniority, and whether they are able to handle the assignment they are supposed to. The client has implemented internal procedures that ensure objective choices in the commissioning non-assurance engagement. So, when accepting an assignment or after accepting an assignment, you come across certain threat. Evaluate that threat, apply safeguards as discussed earlier, and if the threat is reduced, then go and accept this assignment. But if there is no possibility to reduce the threat or mitigate the threat, then you may have to decline the assignment. Now, revised Code of Ethics 2019. So let us see the major changes that has happened in this revised Code of Ethics 2019. Introduction of nuclear. Earlier, there was no such provision. Now, we have to respond to the non-compliance of laws and regulations. So earlier, right now we are supposed to report when there is a non-compliance with the Income Tax Act or Companies Act according to the Act. But now we are supposed to respond to all the non-compliances in any other law. Now, there was no prohibition on taxation services to audit client, whereas now there is a restriction on the taxation services to audit client. Prohibition on management responsibilities to the audit client, which was not there earlier. 40% earlier, there was a 40% restriction on fees from an audit client. Now the restriction is 15%. So if you are getting your revenue is 100 and 15% of that revenue you are getting from a single client for 2 consecutive years, then your duty that in this case our duty is to communicate the situation with the TCWG and assess the situation whether it is affecting your independence or whether it is affecting your decision making capacity. Is there any threat involved, and apply the safeguards, and if you are not able to reduce the threat, then you may have to decline the assignment. Duty of accountant in case of unintentional breach of independence standard, which was not there earlier. It has been introduced now. And there's a new concept that has been introduced, that is key audit partners, public interest entity, etc. Now, NOCLAR fees of relative size and taxation services to clients. These provisions are deferred to 30th September 2022. Other changes. Independence of assurance engagement. So 2009 spoke about independence of assurance engagement. 2019 speaks about independence requirement of audit and review engagement and other assurance engagement, which are differentiated. Earlier, it should word was used. Now it has been redrafted to and been used as shall. They are using shall now. Okay. So now major changes. All the paras are starting with R or A. R is imposes obligation that it is required to be complied, and A is in a guiding nature. It is a kind of explanation or suggestion for actions or like this. See, first R260.6 denotes that it has to be complied. It has to be complied, and A is in a nature of guiding, or it is in guiding nature, or it is explanation, etc. Now, management responsibilities. So, Code of Ethics 2009 did not have this mentioned. This did not have this. 2000. It is new with 2019. All the firm should not assume a management responsibility for an audit client. For example, there is a new concept called virtual CFO. So, in the name of virtual CFO, we are doing the same. We are assuming the management responsibilities. We are taking in the day-to-day transaction. We are taking part in the day-to-day transactions. So that is management. Indirectly, we are dealing with the management responsibilities only. The only thing is the name has been changed. So that is not at all allowed now. Providing administrative services to an audit client does not usually create a threat. For example, preparing administrative or statutory forms for client approval and filing those forms same as it is as instructed by client, and monitoring statutory filing days and advising an audit client of those dates. So that will not be considered as a management responsibilities. Unintentional breach of code. So if, it came to my notice. It came to my notice that I have contravened the laws of this code. So then what should I do? That mechanism of self correction is prescribed in the code. Okay. It mentions the steps to be taken in case of breach of independent standards, that is parts 4A and 4B. A professional accountant who identifies breach shall evaluate the significance of the breach and its impact on the on ability to comply with the fundamental principles. So what I'm supposed to do is I should evaluate the significance of the breach, that and the significance of the threat involved, and how I would apply the safeguards, what safeguards I will apply, and whether my because of that I'm able to mitigate or reduce the threat. If I am able to mitigate or reduce the threat, then I should accept, or if I am not able to, then I should not accept. Next is public interest entity. So this new term, public interest entity, has been introduced in Code of Ethics 2019. PIE is defined as a listed entity or an entity defined by regulations or legislation as a public interest entity, or for which or it is required by regulation or legislation. Okay, so for the purpose of definition, it may be noted that banks and insurance companies are to be considered as public interest entities. And since banks are considered as a public interest entities, branches of the banks will also be considered as a public interest entities. And that is a huge requirement of documentation. So since many of us are the auditors of the branches of the bank, we should make sure that we comply with these requirements. New term, new concept, key audit partner has been introduced in 2019 edition. We should assess that who is the responsible for the particular engagement, which partner is the key audit partner, which partner is responsible in the decision making in judgment of the significant matters, etc. Why? Because key audit partners are, because the signing partners are not supposed to sign the same client's balance sheet for more than for 7 years. Okay, so there is a rotation requirement in Code of Ethics. Requirement restricting key audit partners for being compensated for providing non-assurance service to the clients. Key audit partner cannot be or anyone cannot be compensated for the providing non-assurance service to the clients. Restriction on key audit partner to join audit client, which is public interest entity, if independence is compromised, obviously. Now, let us start with the practical case studies. Certification of projection. In order to claim benefit of Section 115 BAB, ABC Private Limited was in a process to incorporate a new subsidiary for its upcoming venture. Considering the substantial investment was required, it approached banks for funding the said venture. On direction of banks, ABC Private Limited was approached Mr. Sachin to certify the futuristic financial projection of new venture. Mr. Sachin certified the futuristic financial projection prepared by ABC Private Limited without mentioning the basis of the projections and without quoting of view. So first question is, can we certify the projections? So we all know that standard on assurance engagement, SAE 3400, the examination of prospective financial information is applicable to reports on projections and forecasts issued on or after 1st April 2007. So in this case, it was applicable. So what a chartered accountant supposed to do? Chartered accountant can participate in the preparation of profit or financial forecast and can review them, provided indicates clearly in the report the source of the information, the basis of the forecast, should obtain sufficient appropriate evidence that financial information is reasonable, major assumptions while arriving at the forecast, and does not vouch for the accuracy of the forecast. So without doing all this, you cannot participate in the projection, in signing the project, in certifying the projections. Same opinion would also apply to projections made on the basis of hypothetical assumptions about future event and management actions which are not necessarily expected to take place, so long as the auditor does not vouch for the accuracy of the projections. Okay. So in this case study, what are the issues? Audit was not done as per the GAP, AS or auditing standards. So here auditor was supposed to follow the auditing standards, and CA is supposed to comply with auditing standards while issuing the certification. In the instant case, certificate was issued without any compliance of the standard. Hence, he will be guilty of misconduct, failing within the clause 7 and 9 of part 1 of second schedule. Now, non-quoting of UDIN in audit report. So, UDIN is mandatory since many years now. So, member is expected to quote UDIN in all the certifications, all the reports issued by him. So, member is expected, and it is a guidelines issued by the institute. So, member is expected to comply with those guidelines. Now, mentioning of UDIN or audit report certificate issued by auditor is mandatory. Hence, non-quoting of UDIN would be considered as clause 1 of part 2 of second schedule. So, in the case of Harsh, Shreya and others versus Radhakanta Das, it was held guilty for not following council guidelines in terms of members of audits to be signed, in terms of number of audits to be signed. So, we are supposed to follow council guidelines and make sure that whenever our office is issuing any report or any certifications, make sure that routine are quoted whenever mandatory, whenever necessary. Now, second case study, charge of professional fees on percentage of turnover. ABC and Associates was a CA firm providing auditing, taxation, valuation, liquidator, fundraising services, etc. to its client. Whether ABC is guilty of misconduct for below fees charged by it to its clients. In case of audit fees, ABC used to charge its client based on the basis of percentage of turnover of respective client. ABC also charged one of his client at 1% on the total amount of tax saved by client under VSB scheme, irrespective of the result of assessment made by the concerned authorities. With regard to fundraising services, ABC charged fees on the basis of percentage of funds raised by the client. While acting as a liquidator, ABC charged clients fees on the basis of percentage of realization or distribution of assets of respective client. So, as per the clause 10 of the part 1 of the first schedule, CA is not permitted to charge fees on the basis of percentage of turnover except in the circumstances provided. So we are not allowed to charge fees on the percentage basis first. But there are certain exceptions to this act. So let us see what are the exceptions. In case of receiver or liquidator, the fees may be based on percentage of realization distribution of assets. In case of auditor of cooperative society, fees may be based on the percentage of paid up capital or the working capital or the gross or net profits. In case of valuer of purpose of direct taxes and duties, fees may be based on the percentage of value of property value. In case of management consultant service, it may be decided by the resolution of council from time to time. Fees may be based on the percentage of basis which may be contingent upon findings or results of such work. In case of certain fundraising services, fees can be based on the percentage of funds raised. In case of debt recovery services, fees can be based on the amount of debt recovered. In case of cost optimization, fees may be based on the percentage of benefit derived. any other services or audit as may be decided by the council, acting as an insolvency professional or non-acting non-assurance services provided to audit client. In these cases, we can collect fees on the basis of percentage. Now, in the given case study, CA collected audit fees based on the percentage of turnover, which is not mentioned in earlier slides. It is not permitted. Obviously, audit fees on the basis of turnover is not permitted and it will be regarded as a misconduct. Charging of fees at the rate of 1% on the total amount of tax saved by client under VSP scheme, irrespective of result of assessment made by the concerned authorities. So it is not regarded as misconduct because High Court in the case of Himachal Pradesh in HP State for High Court of Himachal Pradesh in the case of HP State Forest Corporation versus S. Butail and the company, it was fees charge held that fees charge is neither based on percentage of profit or result of the case. Hence, case will not fall within the scope of Section 22. Read with clause 10 of the first schedule of the Act. So in this case, it was not based on the what will be the assessment of the concerned authorities. That is why fees charged on the percentage of the total amount of tax saved by client in VSP is allowed, will not be considered as a misconduct. Fees for fundraising charged on the basis of percentage of funds raised not regarded as misconduct as it is covered in the previous slides. Liquidation fees charged on the basis of percentage of assets or realized or distributed, it is not regarded as misconduct as it is covered by exception. Now, a small case, CA had arranged accounting bills raised by 16 parties amounting to 14.09 crore and made entries which were not genuine. Commission at the rate of 0.25% to 1% of the transactions for arranging accounting entries was charged. CA was involved in arranging bogus bills, accommodation entries, and circular transactions for trading in coal through bank LC limits for various other parties. So in this case, CA was arranging any bogus bills and accommodation entries, and he was charging for commission on the percentage basis. So obviously, he was held guilty for professional and other misconduct falling within this code, that is a code that clause that is clause 10 of part 1 and clause 2 of part 4 of the first schedule to the Chartered Accountancy Act. Case 3. When a CA fails to report a material misstatement. So a private limited issued 72,660 shares at rupees 10 each in March 2009. And however, the authorized capital as on March 2009 was 5 lakhs only. Management increased the authorized capital in June 2009 from 5 lakhs to 50 lakhs. Now, management provided form to stat auditor, which was for allotment of additional shares in which authorized capital was mentioned rupees 50 lakhs, which was approved by ROC. Therefore, auditor certified the authorized capital of the company as on 31st March 2009 as 50 lakhs and not as 5 lakhs. It was actually 5 lakhs. From 5 to 50 was done in June, and whereas auditor issued the certificate as on 31st March 2009 that it was 50 lakhs. So here, what is the issue that auditor certified the authorized capital as 50 lakhs and not as rupees 5 lakhs, and allotment of additional shares done was beyond the authorized capital as on the date. So respond here, CA just relied upon the Form 2 and management representation. He failed to check as to when the resolution for increase in authorized share capital was filed with ROC, and also failed to report the material misstatement that allotment of additional shares in March 2009 was void and illegal, as allotment was beyond the authorized capital, which was increased by the company 3 months later to the allotment date. Correct. So he was held guilty of professional misconduct under clause 6 of the part 1 of the second schedule. Now, very big case study, advertisement. XYZ company chartered accountants had shifted to a new premises on the occasion, Diwali occasion. So firm decided to throw a inauguration party as well as Diwali party. So the Diwali party and the inauguration party were planned on a large scale. Then XYZ company decided to send invitations to clients, to non-clients, to friends, to relatives, and reputed people from all across the various industries. So XY in this case decided to distribute brochure along with the Diwali greeting to all the people at the party. And to mark the event, a special logo of firm was designed and published in the invitation and brochure. Now, a close friend of partner X of this firm published a full page advertisement congratulating for newer and bigger office. Ad mentioned the highlights of their services as well. The brochure distributed along with Diwali card contained the following: professional attainment of all the parties along with the photos, information about various books authored and written by its partner was given. It also offered concession on first two services obtained post inauguration. So I'm just revising it. So they are throwing a big Diwali party and inauguration party. So they are sending invitations to many people. They are clients as well as non-clients, and they are distributing brochures along with the Diwali card, and they are designing the logo of the firm and they are printing it on the brochure. And one of the close friend of one of the partner is giving a full page advertisement in the newspaper congratulating for a newer and bigger office, and also obviously इतनी बड़ी पेज में सिर्फ congratulations तो नहीं होगा, so they are highlighting the attainments, highlighting the services provided by this firm. And brochure contain like professional attainments of all the partners and their which books they have written, which books they have authored, and also offer the concession. मतलब first two services पे there is a concession post inauguration. Now, while talking with president of one of the club at party, so they decided to sponsor one of the event of the club. So in party influence, baat mein they are deciding to sponsor one of the event of the club. Now, XYZ company also paid an extra amount to get new address and new contact details printed in the yellow pages or telephone directory. So now, whether XYZ company is guilty of any professional misconduct. So now there are advertising guidelines. Clause 6 and 7 of the part 1 of schedule 1 says many things that you're not supposed to do this, don't do that. Many council guidelines are available on advertising and all. So let us see whether this firm has followed all the guidelines or not. So first they did was sending an invitation card for inauguration and party to clients and non-clients. Now, the invitation was sent to clients as well as non-clients, which is indirect solicitation only. Misconduct as per clause 6 and 7 of the part 1 of the schedule 1, because the card even contained information about the services rendered by the firm, and such card was sent to persons with whom there was no professional relationship. This was held in the case in one of the case. There was no professional relationship. You are sending the invitations to the non-client of your grand party. That is not allowed. Designing special logo and printing it in the invitation and brochure. So use of special logo in visiting card or printing special firm logo is in invitation or any newspaper or any public publication is not allowed. You have to use only your one logo only, CA logo only. So this was held as a misconduct as per clause 7 in one of the case. Now, giving a full page ad in newspaper having details of services rendered. Even though they themselves did not give the ad, but some of their close friends are giving the ad, full page ad. ऐसा भी नहीं कि छोटा सा ad, full page ad. जैसे newspaper खोले ध्यान उस पे जाता है. So full page ad, advertise the ad which had been put for firm was noticeable one, and the profession of chartered accountants should maintain high standard of integrity, professional ethics, and efficiency. If soliciting of work is allowed, The independence and forthrightness of chartered accountant in the discharge of duties cannot be maintained, and therefore some discipline must be maintained by the profession. This kind of acts are not permitted, and such therefore uh, it was held in GP Agarwal case that it is a misconduct. Information about the books written by the partners. So they are giving a brochure to everyone at the party, and there is in that brochure they have written the information about the books authored by the partner and the profession and their professional attainments. So mentioning the details of services and books written along with the New Year greetings. Also remember in the practice can't indicate the book or article authored, contributed, published by him, his association with any firm or of chartered accountants. So you are allowed to author a book. We are allowed to author a book, but we cannot go and publish ourselves like, yes, I have written this book, and we cannot mention in the book that we are a partner in this one. So that was a misconduct. Now, advertising professional attainments. Even you cannot advertise your professional attainments in front of your non-clients. So that is a professional that you are guilty of professional misconduct under clause 7. Now they are offering concession on first two services obtained. Where chartered accountant offered concession in respect of certain services, it was held that it was he was a guilty under clause 6 and 7. You can offer concessions. You cannot offer concessions in any publications. Sponsoring of a club event. So they are deciding to sponsor a club event which is not at all permitted. Only ICI events you can sponsor, but there too there are certain limitations you have to follow. Pay extra to get new address and new contact details printed in yellow pages or telephone directory. You can publish your name in telephone directory. It is permitted, but you cannot, but without paying any additional amount. Making a special request or paying an additional amount to highlight the number in directory is not permitted. Further, the name must be published in chartered accountant section, and also only directory in city in which the firm belongs to. It must be in normal letters. The further publishing numbers and address in yellow pages if results in advertising not allowed. Also, your name should appear in alphabetical manner. Only A, B, and my name is Shreya, so sabse upar Shreya aa gaya is not allowed. And the font size should be the same of others, and anything the any public everything should be the same as of others. Yours should not be differentiated than others. Now, some more examples of professional misconduct due to advertising. Issuing printing circulars highlighting professional attainments, issuing circulars letters to other CAs, or circulation of letter to small group of clients for solicitation of work or to persons who are likely to require the services of a CA is not allowed. So even your employee where your employee's previous employer is looking for a CA, but you cannot go and make a roving inquiries that we are looking for a CA. I am ready to provide you the services. You cannot do that. Advertisement in newspapers seeking work from other professionals. Advertisement for soliciting clients under box numbers in the newspaper is prohibited. So another case study. Mr. B has been appointed, is a chartered accountant, and he's been appointed as a director in the board of a listed company. Company is planning to come up with a publication about their upcoming project. So company is going to mention chartered accountants' expertise, specialization, and knowledge in the upcoming publication. So here a CA is appointed on the board of a listed company, and that company is coming with a publication and thinking to mention chartered accountants' expertise and specialization and professional attainments in that brochure. So with the here, Mr. Here chartered accountant himself is not giving any publication, not giving his advertise or not writing his professional attainments in any publication, but company is writing on behalf writing for chartered accountant. So whether that will amount to misconduct. So publishing description about chartered accountants. Issue is publishing description about the chartered accountant's expertise, specialization, and knowledge. Attention should be given to the clause 6 and 7 of the part 1 of the schedule 1. Inclusion of name of member does not contravene the above provision, noted provision. So mayor just including the name of this person, that he has been on our board for this year or he has just joined our board, is not a contravention of any provision, but take steps to ensure that any description does not amount to direct or indirect solicitation. Invite the attention of management of the company to the aforesaid provisions and the uh, tell them that the material pertaining to member should if possible be approved by him before publishing. So here member has to make sure that management is aware about these two clauses and make them understand that you cannot write these things about me, and before issuing any publication, please uh, give it to me to check it whether you have written anything unnecessary over there. But even though it is not, there is no proper judgments or proper decisions or guidelines available by council, but council has said that kindly make the management aware about these clauses and make sure and try to make sure that they do not print such exaggeration of their specialization or professional attainments in any of their publication. Now, some more examples of professional misconduct due to advertising. Highlighting expertise in letters. So whenever you are issuing a letters and you are highlighting your expertise is prohibited. Writing letters to company highlighting expertise in various areas is another form of roving inquiry. It is prohibited. Announcement in newspaper about changes in the constitution of partnership or address, it is permitted, but the announcement should contain bare minimum facts. You should not write anything extra over there. Application of empanelment of allotment of audit permitted but cannot make roving inquiries as to whether such panel is maintained. So you cannot have a tea with the member of that person responsible for this giving audits and mentioning your name in panel. You cannot have a tea. You cannot meet him. All these things are prohibited. You can just apply in the uh, empanelment of a allotment and wait for your time. Tenders, responding to tenders is permitted. Publication of books or articles, it is permitted, but association of any firm, our firm name should not be mentioned in that books and articles. Issue of greeting cards or invitation is permitted, can be sent to clients, relatives, and close friends. Designation chartered accountant, the name of the firm is permitted. Any other professional designation, status, and qualification is not permitted. Classified advertisement in journal or newsletter of the institute is permitted, but only in the journal or newsletter of the institute. You cannot give advertisement in any other journals or institute or journals or newspapers. Giving public interview is permitted, but make sure that interviewer uh, does not talk about your professional attainments and talks and you're not supposed to talk about the firm. You're supposed to talk about that. You can talk about your firm name, but you cannot say my firm is associated with this international party or this international organization. Not like that. You can just say I am the partner of this firm. That's it. Now, photographs are permitted, but provided no payment is made for such application, no reference to the name of the firm. Signboard of office is permitted, but use of low signs or lights or neon lights should be avoided. And it should not look cheap, it should look professional. Effective on advertisement and solicitation. CA designation along with the name of chartered accountant. Sorry, 1 second. CA designation along with the name of chartered accountant firm can be used on greeting cards or invitation, provided such greeting cards or invitations sent to only clients, relatives, and friends. So you can send invitation of marriage and you can write that I am a chartered accountant and all. But only to the to our existing clients. It should be sent to our existing clients and close family members and friends. Member in practice engaged in the teaching coaching activities in accordance with the general and specific permission of the council should abstain from advertising their coaching classes, as it may amount to indirect solicitation. So if you have if you have your own coaching classes and you are in a practice, then you should not be advertising it your coaching classes. Now, networking other than those registered with ICI are not allowed. For example, BNI and other networking organizations which are not registered with ICI. So, past 2 years, ICI has been sending the notices to the members of this BNI who happens to be into practice, which is not allowed because it is not allowed. Now, logo, you use common logo. You cannot design a special logo. Sponsoring activities is not allowed. Only in the event of POU of ICI is allowed. And CSR activities followed with the prefix CA is allowed. Sharing of educational video is allowed, but reference to CA firm cannot be given. Movie or TV credits are allowed, but should not appear differently from that of others. Now, size of signboard should be appropriate and visibly allowed. Glow signs or neon signs are not allowed, and it should look professional. Printing vision and values behind visiting cards not allowed. Even photos on visiting cards are not allowed. Expression ISO certified on letterheads is not allowed. You can get your form ISO certified, but you can not write it on letterheads. WhatsApp messages about services rendered not allowed. Now, website and the content on the website. Para 3 and 4 of website guidelines issued by ICI prescribe that chartered accountant or chartered accountant firm should ensure that none of the information contained in the website to be circulated on their own or through email or by any other mode or technique except on a specific pull request. Basically, website must run on a pull request and not on a push model. Passport size photo is allowed on website. Name of clients and fees charged cannot be given. Mention of catch words or catch phrases like firms like excellence in a particular area or firm having professionals this integrity or firm is connected with this international organization, etc. is not allowed on firm's website, as well as letterheads and visiting cards is not allowed. CA can provide facility to clients to access its documents through logging in on the firm's website, subject to security and okay. So now we can give our client a specific login ID and password so that they can log in into our website and download their acknowledgements or returns, etc. But we have to make sure that confidentiality and security measures are not affected. See, logo background color on website cannot be changed. Our logo background is white and you should not make it transparent to the website color. It should be white only. Now, case study 6, communication with the previous auditor. Now here, Mr. X, chartered accountant, was approached by client for appointment as a tax auditor under section 44A. Client informed him that previous auditor was out of station, so client was in a hurry to file the return before due date. So Mr. X accepted the audit and commenced the work within 2 days of it. Now, while going through the client financials in the list of sundry creditors, fees of the previous auditor was shown payable. Mr. X did not check how the fees was paid. Before signing tax audit report, he sent communication to previous auditor under certificate of posting without any acknowledgement. So here, Mr. X is in a practice and he has been approached by a client for appointment as a tax auditor under section 44AB. Now, client informed him that previous auditor was out of station. When he asked, so he said the previous auditor was out of station, and since the due date is coming near, so please do my work. So he is accepting the audit and he commenced the work. within 2 days of it without communicating with the previous auditor. Also, while going through the financials in the list of sundry creditors, fees of previous auditor was shown payable. Now, Mr. X did not check the how the fees was paid to him. Okay, so let us see if there is a misconduct by Mr. X. So, first of all, whenever we are accepting an audit assignment, clause 8 says that we are supposed to communicate with the previous auditor. Correct. So here Mr. X did not communicate with the previous auditor before accepting an audit assignment. So he is guilty of professional misconduct under the clause 8 of part 1 of schedule 1. Now, positive evidence of communication was not there. So how you are supposed to communicate with the previous auditor? By whenever you send a communication, make sure that you get an acknowledgement of the delivery. By usko, you should have an acknowledgement written. You should have an acknowledgement that the communication done by you has been sent to them, has been delivered to this previous auditor. If in this case, Mr. X sent the communication by certificate of posting and which did not warrant any positive evidence of delivery. So in this case, it will amount as he has not done any communication only. Okay, so make sure whenever you send the communication, you send to the prescribed mode of delivery only, and you have the positive evidence. You have the written acknowledgement in your hand that the communication has been delivered to the previous auditor. Now, he accepted the audit before checking that whether undisputed audit fees was paid or not paid to the previous auditor. As per council guidelines, incumbent auditors should not accept audit assignments when there is undisputed audit fees outstanding of chartered accountants. So what is undisputed audit fees? When there is a chartered accountant's name is mentioned, the previous auditor's name is mentioned in the sundry creditors schedule of the financials, which are signed by both the parties, by auditor as well as by client, and you can see that the previous auditor's amount is outstanding, then that is the undisputed audit fees. So that has to be paid in fully before you accept the audit assignment. Okay, here okay, in the exception is only sick units whose net worths are eroded. In that case, you can go ahead without and accept the audit assignment without clearing of the fees. But in other cases, you cannot accept audit assignments unless the undisputed audit fees of the previous chartered accountant is paid in fully. So here he did not check, so that's why he is guilty of professional misconduct under clause 6 of the part 1 of the schedule 1. Now, what is the intention behind this clause? Not only the professional courtesy alone, professional courtesy is one of the intention, but also it gives the opportunity to know the reason of the change. Why there is a change? Was there a fault of chartered accountant, or what is the reason the client wants to change the chartered accountant, or why the chartered accountant is resigning? So you can know the reason, and by knowing the reason, you can safeguard your own interest and safeguard the interest of the public at large. And you can assess whether to accept this assignment or not to assign or not to accept this assignment. That is, you can, after communicating with the previous auditor, you have a decision making whether to accept or whether to not to accept this assignment. Now, professional reasons for not accepting the audit assignment. Non-compliance with provision of section 139(1) and 140 of the Companies Act 2013. So clause 9 of the part 1 of the schedule 1 says that you have to check whether the client has complied with the 139(1) and 140 are complied or not complied. So auditors appointment, removal, resignation are in line with the Companies Act requirement or not, that you have to check first. Then non-payment of undisputed fees by auditee other than in case of sick unit. So as learned earlier, that undisputed fees that is there in the financials of previous year under the sundry creditors in the name of the chartered accountant, that this fees to be paid to this person. If that undisputed fees is not paid to that person, to that previous chartered accountant, then you should not accept the assignment, or make sure that you accept only after that fees is paid in full. Now issuance, even even with regards to other fees which is not there, but which is not undisputed fees, but other fees of previous chartered accountant. So you are accepting this assignment because undisputed fees are paid in fully, but there is the other fees which is not mentioned in this financials, but is yet to be paid to the previous auditor. In that case also, use your influence and power so that client makes the payment to the previous chartered accountant in full. Okay, now next reason for not accepting audit assignment is issuance of qualified report. So you have to assess whether the qualified report, whether the previous chartered accountant was wrong in issuing the qualified report. If he was wrong, then you can go ahead and accept the assignment. But if, because he issued qualified report, the client is now changing the auditor, then in that case you should not appoint you should not accept the appointment, because this will this will be like कि, if you are not accepting, if you are not in the client will be like, if you are not giving if unqualified report, then I will remove you next year and I will appoint another C. So we do not have to uh, हमें ऐसे practices को बढ़ावा नहीं देना है. Therefore we should not accept appointment in case the auditor has issued qualified report and he is right in doing so, but therefore client is changing the auditor. In such cases we should not accept the audit assignments. Now other factors are communication, other factors of communication with the previous auditors. Whether I should communicate also in the cases of special audit, bank audit, government audit, yes, it is my responsibility to communicate in any of the audit cases. I have to communicate with the previous auditor. Also, when the previous auditor is not a chartered accountant, or previous professional is not a chartered accountant, in those cases also I have to communicate. It would be healthy practice to communicate with that person. Now, do I have to have NOC in my hands before accepting audit assignment? No. The what clause 6 says that you have to send communication. You have to send communication to the previous auditor in the prescribed mode, and you have to have delivery acknowledgement that this communication has been sent or delivered to that person, to the previous auditor. Okay, and what you have to write in the communication that this client has been approached to me to accept to take this assignment. However, I would like to know whether there are any objections from your side, or there are any pointers or information that you wish to share with me. If there are no objection, if I do not receive NOC within reasonable period of time, mentioned period of time over there, if I do not receive NOC within a reasonable period of time, then I will go and accept the assignment. So, and after sending the communication, you should have a documentation that yes, you have sent it, the communication has been delivered to the previous auditor. Now, what is reasonable period of time? The council has not specified or not given any reasonable period of time anywhere, but according to me, it should be between 10 to 15 days, again depending upon the situation. Don't follow it thoroughly, but it should depend upon the situation where the firm is where the previous auditor is situated, and how you are communicating, which mode you are preferring to communicate with him. If it is email, then 7 to 8 days are enough. Okay, now short timeline given for acceptance of audit. In that, so in many cases, many government audits, you have to accept the audit immediately or within a 1 or 2 days. So in that case, it is quite difficult for us to take out the information that who was the previous auditor, and take out his email address, or take out his registered address, or take out his any other contact details. So it is quite difficult. So in that case, what we can do, we can give a conditional acceptance that I am accepting this audit assignment, subject to the condition that NOC being received from the previous auditor. Okay. Now, is there any duty cast on previous auditor? So as of now, we learned about that incoming auditor has to do this and that, but what is the duty of the outgoing auditor? So whenever, as an outgoing auditor, I receive an letter or communication from the incoming auditor that for NOC, then it is my duty to give him the no objection certificate. And if there are any objections, please write back to that person so that he can come to know. Or if there are any information that according to me should be in his knowledge before he accepts the assignment, then please write him back that these are the pointers or these are the information I wish to share with you. Okay, whatever are the things, please reply back. Not that is not a please. Actually, you that is a duty that as a outgoing auditor to reply back to the incoming auditor. Now, what are the prescribed mode of delivery? What were the prescribed mode in 2009 and what are the prescribed mode in 2019? So, first is registered acknowledgement due. 2009 said registered acknowledgement due. 2019 said communication by letters sent registered acknowledgement due. मतलब communication by letter, but you should have a registered acknowledgement that this communication has been delivered to the previous auditor. By hand against a written acknowledgement, and it is the same by hand against a written acknowledgement, but again you should have a written acknowledgement that this has been delivered to the previous auditor. In 2019, the addition is you can send communication via email address registered with the institute or last known official email address. So now the query is coming to the client council that which email ID to be followed, registered one or last known official email ID. So in that case, you can send on both the email IDs or you can choose any of the email ID, but make sure that outgoing auditor is responding to the email that okay uh, okay or we will reply soon. Anything is okay, but there should be a email from the previous auditor that he has received your communication. Okay. And through UDIN also you can communicate, but that has not been yet clarified by council. Now, comparison between the old and revised code. So, what if you are sending the communication but the premises is closed? So 2009 was silent in that case, but revised code of ethics says that communication received by incoming auditor with office found closed written on the acknowledgement shall be deemed as delivered. So you are sending a communication and receiving the acknowledgement stating that the premises was locked. So that is okay. You have done your part, so you can relax now. Firm not found at the given registered address. So in that case also 2009 Code of Ethics was silent. 2019 says that if communication is received with the remarks that no such office exists at this address or address is registered and the address is registered with the institute. So you have to send on that address that is registered with the institute, and if you are receiving the communication back that with the remarks that no such office exists at this address, then it is okay. You have done your part. But in that case, if retiring auditor proves that the communication was not served on him at all, then that is a problem. So certificate in 2009 Code of Ethics, certification was considered in case of certification also communication was considered as a healthy practice. In revised Code of Ethics, it has been dispensed with. Then short timeline given for the accepting of the audit. 2009 code was 2009 Code of Ethics was silent, whereas revised Code of Ethics says that you give a conditional acceptance that we are accepting the appointment because of your timeline given, subject to the NOC being received from the previous auditor. Now, to small FAQ on the communication. Can professional accountant accept the communication immediately after intimating his appointment over phone to the previous auditor? So I know this previous auditor, he's a friend of mine. So I'm calling him and telling him, I have got this assignment of yours, and so is it okay for you if I accept the assignment? He says, yeah, it's okay, continue, continue. So then after keeping the phone, I'm immediately accepting that assignment. Is that allowed? No, because communication is to be done in writing, and you have to wait for a reasonable period of time to reply to be received. You cannot just communicate over phone. Whether communication with the retiring auditor is permissible via SMS or messaging application? No, you cannot WhatsApp him or send a text message for the communication. You have to do it via the prescribed modes only. Now, case study 7 is whether you can be engaged in any as a CA in practice. Can you be engaged in any other business? So Mr. A, a CA in practice, is engaged in derivative transactions, uh, future and option transactions. Please give me a moment. Thank you. So next case study, Mr. CA, who is a CA in practice, is engaged in derivative transaction, that is future and option. He is a Karta of the HUF, and in his capacity as a Karta, he is undertaking some derivative transactions on stock market. So here he is also engaged in a personal capacity in a derivative transactions, and also he's a Karta in HUF, and he's also carrying the derivative transactions on the stock market in the name of HUF. He has also taken sub-brokership from a stockbroker, enabling his client to trade on stock exchange. So he is also a sub-broker. Okay. So whether it is allowed, let us see. Carrying out derivative transactions in the personal capacity. Council has a year back only granted a permission for carrying out the derivative transaction on a personal capacity. But the permission is only if you carry transactions in personal capacity. You cannot carry transactions in your proprietary firm or in your partnership firm, or even in HUF as a Karta. Okay, member cannot carry derivative transaction as a Karta in HUF, and also cannot become actively engaged in the business of HUF. Okay, so also for that you have to take a prior permission from the council. It is not generally prescribed, so you have to take a prior permission from the council, and therefore here member was actively engaged in the derivative transaction in the HUF, and also he had taken sub brokership in the name of HUF, and he was as a Karta, he was actively engaged in all this. So without taking any prior permission from the council, therefore he was held guilty of professional misconduct under clause 11 of the part 1 of the schedule 1. So position as a Karta in HUF, it should result from inheritance, succession, partition of the family business only after specific and prior approval of the council only. Should not have active role in the business of the HUF. You should not get engaged in the actively in the business of the HUF, even though appoint a member of the HUF family member to carry on these transactions, but do not get involved. Do not involve yourselves. Attest functions are not permitted. Now, clarification has been incorporated that uh, a member engaged as a Karta of HUF doing family business will be within the limit prescribed by the council if he makes an investment from the funds pertaining to HUF only, provided he is not actively engaged in the management of said business. So you are not managing the business, but you are investing from the funds that are of HUF only, then that is allowed. So FAQ and derivative transactions that recently council has posted. So whether a member in practice can transact in derivative transaction, yes. It is permissible for member in practice to transact in derivative transactions in individual capacity only. And what are the types of derivative instruments and products? Only future and option derivatives and equity and currency derivatives. Commodity derivatives are not allowed, and whether member are allowed to transact in derivatives transaction in the name of his proprietary firm or partnership firm. No, you cannot transact in any of your firm's name, but only in your personal capacity. And only future and option and equity and currency are only allowed. Commodities are not allowed. uh, so why there are restrictions on us being a CA in practice? Why we cannot engage in business in other businesses? Because it if uh, we are engaging ourselves in other businesses, then we have to take out the certain amount of time from our practice only. So that is going to affect our decision making capacity, our professional judgments, and our efforts towards our practice, and it can affect our services to our clients. So that is why it is not allowed. So we have received a question from Rajesh Shreya that when in personal name derivative transaction allowed, then why not HF? Why only doing derivative transaction? No, not only derivative transaction. You cannot engage yourself in the business of in any business of HF, because as I said, when you are engaging yourself in the business in any of the other business, then you are taking that time from the practice only, correct? So that is so. So that will affect your services towards your client, that will affect the credibility, your credibility only. So that is why council has said no for any of the business engagements in any other engagements without taking prior permission of the council. So if even if you want to undertake such engagements, you have to take the prior approval from the council. So derivative transactions in the HUF are not allowed because sole reason, because any business is not only derivative, any business is not allowed because you have to take your time from that practice. Correct. When HUF has only derivative transaction, so okay, but you must also be doing derivative transaction in your name, then HUF, then your practice. So many things. So see, it is not that the this was the case study that I have taken, that derivative transactions are not allowed in the name of HUF. It is not that only that council has said that any business is not allowed in the name of HUF, in the name of HUF. And derivative the transaction in the derivative is a business only, therefore it is not allowed in the name of HUF as well. Why it is allowed in our name? Because while giving permission, council said that many started account is already engaged in this in derivative transaction in their name. That is why council had to give a permission. But these were the wordings of the council. So हमें भी उन्होंने जबरदस्ती परमिशन दी है, तो HUF को वो हिसाब से परमिशन नहीं मिलेगी. फॉर दैट यू हैव टू गो एंड आस्क स्पेशल परमिशन फ्रॉम द काउंसिल. Moving ahead, CA in practice eligible to become director. So can I become a director if I'm into practice? So managing director or whole time director, I have to take a permission from the
Sorry, yeah, sure. Please continue.
Okay, so for managing director to become a managing director, full-time director, I have to take a permission from the council. And for promoter or promoter director, yes, it is allowed. Whether can I be director simpliciter? Yes, it is allowed. You do not have to take any special permission from the council. Now, what is director simpliciter? He is only required to attend the board meetings only. He will not be paid any remuneration except the sitting fees for attending the board meetings. No other remuneration to be paid. And he will be devoting his time for the company only to attend board meetings and not for any further other purpose. You cannot engage, then you cannot engage yourself in the managerial decisions of the company, etc. Okay, only for the you can only attend the board meetings and you can devote your time only to attend the board meetings, and you cannot sign the ROC forms. ROC forms. Well, CA in practice was entitled to manage the finance of the company, to close deals with the outsiders and the other such managerial duties deemed to be a managing director. So you are into practice and you are engaging yourself in managing the company's finance and to close deals with the outsiders. That is not your job, correct? But if you are engaging yourself in such duties, then you are into managerial duties. So then you have, if you have not taken the special permission from the council, then you are liable for professional misconduct. Auditor of subsidiary company cannot become director of holding company. No equivalent director simpliciter in LLPs. A member in practice cannot become a partner or designated partner in an LLP, not carrying out the profession work. So you cannot become a partner which is not in LLP, which is not into the professional work. Now let us see that what are the general permissions given by the council and what are the special permissions, and other than, okay, first let's go for general permissions. Authorship of books and publications, articles. Yes, you can obviously author the books and articles, but only thing is that you cannot advertise your professional attainments in the those publications, and neither you can talk about your that you have authored these books or you authored these articles in general. Holding of life insurance agency license for limited purpose of getting renewal commission. Attending classes and appearing for any examination. Holding of public elective offices such as MP, MLA, MLC. Honorary office of office bearership of charitable, educational or other non-commercial organization. Acting as a notary public, justice of peace, special executive magistrate, and that like. Part-time tutorship under the coaching organization of the institute is allowed. Valuation of paper, acting as a paper setter, head examiner or moderator for any examination, not only say any examination. Editorship of professional journals. Not if you are not in employment of that company, then you can become the editor of the professional journals. Acting as a surveyor and loss assessor of the Insurance Act, but not in employment. Acting as a recovery consultant in banking sector. Private tutorship, owning agricultural land and carrying out agricultural activity. Engagement in any other business or occupation permitted by the executive committee from time to time. Now, a member who is not entitled to perform a test function shall not be entitled to train article assistants as well. Now, what are the special permissions? Full-time or part-time employment in business concerns, provided that member and or his relative do not hold substantial interest in such concerns. Full-time or part-time employment in non-business concern. Office of Managing Director or Full-time Director of body corporate within the meaning of Companies Act. Interest in family business concerns or concerns in which interest has been acquired as a result of relationships and management of which no active part is taken. Interest in family business and or concern in which interest has been acquired as a relationship, just like you are becoming a karta of HUF because of succession and you are not managing the business. Interest in educational institution, part-time or full-time leadership of for courses other than those relating to institutes examination conducted under the auspices of institute or the regional councils or their branches. Part-time or full-time tutorship under the educational institutions other than coaching organizations of the institution. Editorship of journal other than professional journal is also allowed, is for that special permission is to be taken up, and any other business or occupation for which executive committee considers that permission may be granted. Now, another case study is gross negligence. So, statutory auditor gave certificate certifying that entire promoter's contribution of rupees 225 lakhs had been received by the company. So here, auditor is giving certifying the amount that promoters of rupees 225 lakhs have been received by the company. Now, auditor had checked share application account maintained by the company, bank book showing the receipt of the payments in the form of checks deposited, and the bank deposit slip counterfoils duly bearing the bank acknowledgements of the check deposited. So he checked that the checks are also deposited in the bank. Respondent issued certificate on the basis of above documents produced before him on the date of issue of certificate. So company produced all these documents, share application account and the check deposit counterfoils, that and with the attestation of bank that check has been deposited. All these documents were produced before the CA, and he checked it and then he issued the certificate. However, check deposited by the promoters were bounced, due to which only 35 lakhs were received by the company. So out of 225, only 35 lakhs checks were clear, worth checks were cleared, and other checks were bounced, that which were given by the promoters. So respondent was in a good faith that checks deposited would not bounce. He just checked the check deposited slips. He did not check whether the money has been actually credited in the bank or not. So, keeping in the view the past track record of the promoters, he thought that the checks will absolutely clear, and he gave the certificate. Now, issue is auditor issued certificate without taking due care. Auditor relied upon the documents submitted by the company. The respondent was held guilty of professional misconduct under clause 7 of part 1 of second schedule, and to have abetted the promoters in the fraudulent activity by issuing a false certificate, as he could have issued the certificate with the remark that subject to realization of check deposited. Instead of doing so, respondent issued the certificate as if the entire contribution has been received. So here, he could have issued the remarks in the certificate to subject to realization, or he could have waited till this clear till the clear till the credit in the bank account. So he did not do so. That's why he was guilty of professional misconduct. Clause 9, case study 9, incorrect certifications. So Mr. Papu, he is a director of a Hari Private Limited, with the mala fide intention, informed Mr. CA in practice about the resignation of two directors from the company. Now, Mr. A certified Form DIR 12 for filing the with ROC without verification of resignation letters and certified board resolution. Thereafter, Hari Private Limited company was approached by Mr. CA to certify the present shareholding and directorship of the company. Now, CA asked his article assistant to prepare certificate based on the last year. Now, inadvertently, article assistant failed to give the effect of resignation of director, and certificate was blindly signed by Mr. A, that is a chartered accountant. Banks wrote several letters to chartered accountant for discrepancy in the director's details as per certificate and as per the ROC. However, A did not reply. So, is there any misconduct? So, what has happened? This company, with one of the director of the company, with the malified intention, informed the CA that these two directors has resigned from the company. So, chartered accountant filed form DIR 12 without giving due effect, without looking into board resolution or without verification of any resignation letter. So he just filed the form DIR 12 without looking into any documents. Now thereafter, company approached CA to certify the present shareholding, to ask for the certification of the present shareholding and directorship of the company. Now what the chartered accountant is doing, he's telling his article assistant, they prepare this certification based on last year. Now, article assistant is not checking on the website of ROC. He's just copy and paste and giving the certificate, and that certificate is also signed by this chartered accountant. So bank is asking the bank is writing several letters to the CA that why there is a discrepancy between the ROC site and your certificate, whereas CA has not replied. So let us see what are the issues. That first issue is filing of director details with ROC without board resolution. So here it was a responsibility of the chartered accountant to go through the board resolution to resignation letter, but he did not check anything and he just filed the form 12. So certifying ROC without board resolution results in gross negligence on part of CA, bringing disrepute to the profession. Guilty of other misconduct and guilty of the other misconduct as per clause 2 of the part 4 of the first schedule to the Chartered Accountants Act 1949. Now, reliance was placed on article assisting for preparation of certification, resulting in gross error. So, employer made implicit reliance placed implicit reliance on the certificate prepared by the article assistant without giving effect to the resignation of directors. Since he blindly relied on the work of article assistant without verification, he is considered as guilty of misconduct. So here you cannot take shelter on the thing that this was not done by you, it was done by your employer or your article assistant. No, your sign is on that certification, you are liable of professional misconduct. So this can be practiced in many of our offices. So we have to make sure that we go whenever. So sometimes what happens, like our offices use our digital signature and file any written or approve any forms or file ROC forms with our digital signature without we checking into it. So let us give a practice that one senior person or one chartered accountant goes through that forms or goes through that reports before they attach our digital signature. Now, third issue is that failed to verify certificate in spite of repeated inquiries by bank. So when certain bank authorities are approaching to you that you have done this mistake or why there is a discrepancy, answer it to us, and you are not replying to them, then that is obviously a professional misconduct. It is our duty towards your client and towards your towards a part of professional assignment that you are supposed to answer to them. Bank made several attempts to approach CA for discrepancy in certificate. However, same was not replied back. Since he failed to reply within reasonable time, he was considered as guilty of professional misconduct. Last case study, 10 non-compliance with the guidelines. January Private Limited was engaged in business of manufacturing, however, had no operating income for the year on account of COVID pandemic. Of the balance sheet size of 100 crores, more than 60 crores were granted as a loan to another company. The interest income received thereon was received in cash basis. So here CA issued clean audit report to Lender Private Limited, and whether the chartered accountant is guilty of professional misconduct. So what happened here, that company had no revenue, but still company gave huge amount of loan, granted huge amount of loan to another company, and the interest income that was received on a cash basis. And still and even after all this, the CA is issuing the clean audit report. Let us understand where the misconducts are. Failed to report that company had carried on the business of NBFC. As the company had no operating income and major assets were deployed for the earning passive income, the assessee was carrying on the business of NBFC without obtaining registration of NBFC. It was in the nature of NBFC business, but the company had not obtained any registration of NBFC, and auditor failed to report that such fact, that such a huge amount, the company was earning only passive income and no operating income, and such a huge amount was granted as a loan. After all this, auditor failed to report. That's why he was held guilty as within the meaning of clause 7 of the part 1 of the second schedule. Now, audit was not done as per the gap or applicable auditing standard or accounting standards. So company had accounted interest income on cash basis, which was in the violation of fundamental principle, that is accrual. As per AS1, in case of failure to follow the accrual system of accounting, the CA has to quantify the quantum of debt in the financial statements. Since there was failure on the part of CA, he was guilty of misconduct, falling within the clause 7 and 9 of the part 1 of the second schedule. So make sure that whenever you are conducting an audit or whenever you are issuing audit report, you are complying with all the required provisions, accounting standards, auditing standards, because even non-compliance with the small, with the very, with the AS1 also will land you in a big problem. Now, non-quoting of UDIN. Member is expected to comply with the guidelines issued by the institute. Mentioning UDIN on the audit report or certificate issued by the auditor is mandatory. Hence, non-quoting of UDIN would be considered misconduct as clause 1 of the part 2 of the second schedule. So, as I said earlier, UDIN has been mandatory since many years. So, make sure that we are issuing reports and certifications only after quoting UDIN whenever it is mandatory. It is mandatory in all the case, almost all the cases. So make sure that none of the certificates are issued or reports are issued without the quoting of UDIN by any of our staff member or even by us. We might not realize that this, even if we are right, this small things that we carry in our day-to-day practice may land us in a big problem. Going through a disciplinary mechanism is not, disciplinary actions is not only is way much exhausting. Even though you come, even the pronunciation come as a, even the result come as non-guilty in your case, but still the process of 2-3 years is very exhausting, and you mentally get affected. So make sure that we try to comply with this code of ethics as much as, no, we try to comply with code of ethics thoroughly. So we have enough time for questions. So
Yeah, any questions? Participants can unmute themselves and ask, or maybe in the chat box. None. Yeah, so we'll move to pleasant task of vote of thanks. So Shreya, you have covered perfectly the code of ethics, the new updations since last 2 years, which members may not be aware due to the lockdown and all other stuffs. And the case studies, I think that is the perfect way to explain the code of ethics, so that with easy examples, people may come to know that what are the things to be done or not to be done while you are in practice. I, on behalf of Dadari CP Study Circle, firstly like to thank you for accepting our invitation and propose a well-deserved vote of thanks for your today's seminar. Thanks a lot. Thank you very much.
thank you everyone. Thank you, Parim.